For years, gun owners have heard the same warnings over and over again that states would keep pushing bans on AR-15 style rifles higher and higher through the courts.
New gun debate focuses on the rifle that Adam Lanza used on Friday, the AR-15.
To take on some tougher gun laws.
That eventually the issue would land at the Supreme Court, and that when it did, the court would likely avoid the question just as it has done in the past. But this time feels different. Right now, the Supreme Court is facing a question so direct and unavoidable that it's sending shockwaves through every state with a rifle ban already on the books. At the center of it all is a single issue the court can no longer sidestep. Does the Second Amendment protect AR-15 style rifles and the magazines they commonly use, or can states outlaw them outright? This isn't a dispute over accessories, storage rules, or background checks. This goes straight to the core of the Second Amendment itself. The court is being pressed to say, in plain terms, whether one of the most commonly owned rifles in the United States is entitled to the same constitutional protection as other firearms the court has already addressed. And unlike past moments, the justices aren't dealing with hypotheticals or abstract arguments. They're looking at real bans that are already being enforced, affecting real people across entire states. If the court decides these rifles and magazines are protected, the impact would be immediate. Laws in places like Illinois, California, New York, and other states built on similar frameworks could face serious legal challenges almost overnight. If the court rules the other way, states would gain a clear signal that broader restrictions are constitutionally permissible, opening the door to even more expansive bans. There's no quiet middle ground here. No gentle adjustment. Whatever the court decides becomes the new standard for every lower court, every state, and every case that follows. So, how did we get here? To understand why the Supreme Court is now inches away from addressing AR-15 ownership directly, you have to start at the local level, not Congress, and not a nationwide lawsuit. This case began in Cook County, Illinois. County leaders passed an ordinance that made it a crime to sell, transfer, or even possess a long list of rifles, including AR-15 style firearms. The rule also targeted features lawmakers described as military style, such as pistol grips, folding stocks, threaded barrels, and certain muzzle devices. In effect, the county treated these characteristics as transforming an otherwise lawful firearm into something they believed should be banned entirely. But the story didn't stop there. While the case was still moving through the lower courts, Illinois passed a statewide law that went even further. What began as a local ordinance suddenly expanded into a comprehensive state-level ban. That shift changed everything. What had once been a narrow legal dispute became a statewide prohibition affecting hundreds of thousands of residents. And it created a legal conflict that was almost guaranteed to move upward through the court system. The plaintiffs in the case, ordinary gun owners supported by organizations like the Second Amendment Foundation, didn't argue that the law was merely inconvenient. They argued that the state had banned one of the most commonly owned firearms in the country. They pointed out that AR-15 style rifles are widely used for lawful purposes including training, sport shooting, hunting in certain contexts, and home protection. Their position was simple but powerful. Banning an entire category of commonly owned firearms isn't regulation, it's prohibition. That argument is now sitting directly in front of the Supreme Court. Not as a political talking point, not as a theoretical debate, but as a real ban enforced by law, backed by a state willing to defend it all the way to the highest court in the country. Once the case reached the appellate level, the situation took a sharp turn, not because of new evidence, but because of how the lower court interpreted existing Supreme Court precedent. The Seventh Circuit relied heavily on a separate case to conclude that AR-15 style rifles could be treated differently from other protected firearms. Their reasoning centered on the idea that these rifles are too similar to military weapons to fall under Second Amendment protection. According to that logic, if a firearm shares design characteristics or lineage with weapons used by the military, it can be excluded from constitutional coverage. That approach immediately raised serious questions. In District of Columbia versus Heller, the Supreme Court made clear that protected arms are defined by common civilian use, not by appearance or political perception. Later, in New York State Rifle and Pistol Association versus Bruin, the court reinforced that modern firearms can still be protected if they are commonly owned and used for lawful purposes. Despite that guidance, the Seventh Circuit concluded that AR-15 style rifles fell outside the Second Amendment, even though millions of them are owned by civilians who have no connection to military service. That inconsistency, where the same rifle can be protected in one region and banned in another, is exactly the kind of conflict that eventually forces the Supreme Court to step in. And that's why this case has reached the point it has. When the petitioners brought their argument to the Supreme Court, they didn't rely on emotional appeals or speculative claims. They focused on numbers, history, and precedent. They emphasized that tens of millions of AR-15 style rifles are owned nationwide, that these rifles are used overwhelmingly for lawful activities, and that they are more prevalent among civilians than many firearms already recognized as protected. Then they posed a question that's difficult to avoid. If a firearm owned by tens of millions of ordinary Americans is not protected by the Second Amendment, then what firearm is? That question cuts to the heart of the issue. Either common ownership matters or it doesn't. And if it doesn't, the scope of the Second Amendment becomes uncertain, shifting with political winds rather than constitutional principle. The petitioners also challenged the idea that resemblance to military weapons can serve as a constitutional test. Nearly every modern firearm traces some part of its design history to military use. If resemblance alone becomes the standard, the line between protected and prohibited arms becomes increasingly unclear. This is the pressure now sitting in front of the court. States defending these bans understand what's at stake. They're not just protecting one law or one ordinance. They're defending an entire legal framework that has supported firearm restrictions for years. If the court rules that AR-15 style rifles are protected, that framework could collapse quickly. That's why states like Illinois have argued that the Supreme Court shouldn't even hear the case, claiming there's no meaningful disagreement between lower courts, a claim many legal observers dispute. They've also leaned heavily on the argument that these firearms are dangerous and unusual, a phrase that becomes harder to defend when ownership numbers are this high. At the same time, a second case is moving quietly alongside the rifle challenge, the issue of magazine limits. The Duncan case out of California, which addresses bans on magazines holding more than 10 rounds, is back in front of the Supreme Court. After Bruin, the court sent the case back down with instructions to apply the proper historical test. The lower court upheld the restriction anyway. That move pushed the case back up the chain. Now the court is reviewing both issues at the same time, and that timing matters. Rifles and magazines are legally connected. If one is protected as commonly used, it becomes difficult to argue that the other can be banned without consequence. This brings us to the moment that decides everything. The Supreme Court now has three options. First, it can grant review. If it does, the signal is unmistakable. It means the court is ready to address rifle and magazine bans directly and set a clear national standard. Second, it can deny review. That wouldn't mean agreement with the lower courts, but it would allow existing rulings to stand for now, encouraging states to continue pushing similar restrictions. Third, the court can delay action, a move often referred to as a relist. This doesn't draw headlines, but it can indicate that serious internal discussion is taking place. Overlay all of this with prior statements from justices acknowledging the need to address rifle bans, and it's clear why this moment feels different. If the court steps in and rules that commonly owned firearms are protected, the ripple effects will be felt nationwide. Courts will be forced to follow a clear principle instead of relying on appearance-based reasoning or policy preferences. For gun owners, lawmakers, and courts alike, the decision will reshape the legal landscape for years to come. Right now, the country is waiting for that next move. And when it happens, it won't be a minor update. It will define how firearm rights are interpreted across the United States moving forward. If you want clear, timely updates as this develops, subscribe and turn on notifications. The moment the court acts, we'll break down exactly what it means and what comes next.